when funding by an individual is to a particular political party, then obviously it has to be quid pro quo, because if it is to a particular political party, then obviously the funding by that person will be only to a political party from whom he is expecting some favors or from whom he's already got some favors. Now, if that be so, then I don't see any justification why the funding should be made, as an expenditure in your balance sheet on which you end up not paying any tax. So that was the first wrong with that, with the electoral bond system. And according to me, Supreme Court has done nothing with regard to that. In fact, I believe the PIL petitioners also didn't raise that as an issue. And I think the judgment which the Supreme Court ultimately delivered, saying that this bond is unconstitutional, also did not do the full justice by directing the political parties to refund the money that they had taken against unconstitutional bond and pocketing the money and continuing to use it in the electoral politics. If you really feel, if somebody feels that there should be cleansing in the electoral, funding, and there should be a transparency in electoral funding, then there should be a bond which should be completely, without any political party being identified to that bond. So if that kind of money is given by somebody, if I feel that, well, I also need to be a party to cleansing the electoral process and I want to pay some money, then that money only should be exempt from income tax. That only should be considered as an expenditure, so that you can, claim deduction for having done something good for the government or for the politics in the country.